We will stand up again, we will march again, we will preach again, we will organize again. We are black, we are white, we are Latino, we are Native American, we are Democrat, we are Republican, we are independent, we are people of faith, we are people not of faith, we are natives and immigrants, we are business leaders and workers and unemployed, we are doctors and the uninsured, we are gay, we are straight, we are students, we are parents, we are retirees. We are North Carolina, and we're here, and we ain't going nowhere.
Let us come together in a word of prayer. Gracious God, we give you thanks for victories. We give you thanks because we know that your hand is involved in everything that we do, because we know there are no small victories, and we pray that you may continue to cause us to move forward, to know that you are with us. We give you thanks for this opportunity to talk about what has happened and what the judicial system has said, that there must be an end to voter suppression. There must be an end to inhibiting the rights of individuals to vote in this state and all around this world. Bless us with your presence and your Holy Spirit. In Jesus' name we pray. Amen.
Amen.
Thank you all for coming. Let me first of all thank our entire staff team who works tirelessly in the movement, all of our branch presidents across the state of North Carolina, all the members, all of the coalition partners of the Forward Together moral movement. There is a question for Tillis, Barber, and McCrory. Why is it that they don't want people to vote? Why are they choosing, and their allies, politics over principle?
That's right.
Gandhi once said that was one of the great moral sins, politics without principle. And there is a principle here. It's bigger than the NAACP, it's bigger than the North Carolina state government, it's bigger than the Speaker's office, it's bigger than the Senate Pro Tem's office, it's bigger than any one person. And that principle was laid down in 1870, that no one, no state, no entity can deny, but the second word is important, or abridge, undermine, cut short the right to vote. This is a major victory. It is in fact the first major victory for the sanctity of constitutional voting rights since Shelby. It's a movement victory. It's a victory because of the movement on the ground, people in the streets and in the legislative halls, but also because of our tremendous team of lawyers led by Advancement and Project, Kirkland and Ellis, and our own Irv Joyner, who has a great legal mind and legal history, not only in this state, but in this country.
Yep.
And it is a great victory for our plaintiffs like Rosanelle Eaton and Reverend Dr. Palmer and Reverend Jimmy Hawkins and the churches that have joined to fight against voter suppression. As you all may know, Governor McCrory released a statement yesterday in the wake of the Fourth Circuit Court of Appeals, and once again it is another attempt to misdirect. He said, "I am pleased that the major parts of this popular and common sense bill were left intact and applied to the upcoming election. I have instructed our attorneys to appeal to the Supreme Court so that the two provisions rejected today can apply in the future and protect the integrity of our elections." Senator Speaker Tillis and Senator Barber together released a similar statement. They said, "We are pleased that the court upheld the lion's share of common sense reforms that bring North Carolina in line with the majority of other states, including the implementation of a popular voter ID requirement supported by nearly 3/4 of North Carolina." That's all to the media misdirection. It's misdirection. North Carolina, with these new laws, have actually done something other states haven't done, and that is had more people participate in the right to vote. First of all, these two statements are blatantly deceptive. I probably would use another word, but I'm going to be somewhat professorial today. They are blatantly deceptive. The Fourth Circuit Court of Appeals did not touch the voter ID requirement because that section of the law will not be litigated until next summer, and it has nothing to do with the November 2014 election. They have constantly tried to get the media to talk about this as a voter ID bill. It's been a trick from the very beginning. That's why they voted on it first, because they wanted every headline to be a voter ID bill rather than it be listed as a voter suppression bill, and to expose the depth at which they were attempting to roll back and change the laws in North Carolina. Secondly, the courts did not uphold the lion's share. And Irv will deal with that in a minute. They actually repudiated the Tillis, McCory, Berger rationale. The court wrote, finally, as to the tenaciousness of the reasons given for the restriction, North Carolina asserts goals of electoral integrity and fraud prevention, but nothing in the district court's portrayal of the facts suggests that those are anything other than merely imaginable.
Wow.
Again, that's another word, the court's being nice there. But Grandma would say it's just lying. It's just political imagination, which is the whole basis that they claim they passed all these laws in the first place. Right. The courts go on to say, and states cannot burden the right to vote in order to address dangers that are remote and only theoretically imaginable. Mm-hmm. In other words, it's just in your mind.
That's right.
But it's not in the actual reality of history. Mm-hmm. Secondly, there's nothing common sense about any part of this law. Governor McCory, Speaker Tillis, Senator Berger have set out to fix a problem that never existed. That does not make common sense.
That's right.
Members of the extremist majority in their less tactful moment have actually admitted that. Go pull the tape, we asked the media, of Tom Tillis on MSNBC when he actually said there was no real history of voter fraud. On camera. We applaud the Fourth Circuit Court of Appeal for paying tributes to something that many extremist legislators have repeatedly chosen to ignore, and that is history.
Yeah.
The judges wrote that neither the Supreme Court nor this court has ever held that in determining whether an abridgment has occurred, courts are categorically barred from considering past practices, as the district court has suggested. In other words, the district court judge got the law wrong, suggesting that you could not look at the past in order to deal with the present. In fact, let's get history right here in the first place on how we got here. I'll let Irv deal with more of the technical matters of the law. The lower court found accurate the history of the voter suppression in the lower court that was zipped through the legislature shortly after 5 justices with no shame gutted the Voting Rights Act only a few years after it had been reenacted for 25 more years. On June 25th, 13, the Supreme Court neutered its powerful Section 5 by gutting Section 4. You don't have Section 4, you can't implement Section 5. The same day, let's get the history right. The same day, Senator Tom Apodaca said, so now we can go with the full bill. Or we've been waiting. Now that these 5 justices have gutted Section 5, we can go with the full bill. He also said on the record, I'm glad that we can proceed without the headache of Section 5. This is our legislators talking. Now, the full bill, they tried to get the media just to look at the voter ID. They passed that part earlier, so that would be the headline. But the full bill included voter suppression tactics that ALEC and other Koch voter suppression groups around the country had already tried, tested, and some new ideas that were in the experimental phases that extremists believed, if they implemented them, would hurt African Americans, minorities, poor, elderly, and student voters disproportionately, that great coalition of Americans that they are so afraid of.
That's right.
ALEC and its North Carolina representative Tom Tillis had already put out many of these ideas. 2 at the top of their list was to stop same-day registration, not to prevent same-day registration from coming into existence in North Carolina, but to literally repeal it, to take it away, even after it had been used in multiple elections and had been proven to increase the participation in voting, even among Republicans. And they wanted to stop counting votes for people who were properly registered but mistakenly voted in the wrong precinct, sometimes because of their crazy redistricting plan that they passed in 2010.
That's right.
Let's get this history right. The full bill was kept hidden until the night of 7/22, July 22nd. And then what had been a 12-page bill prior to Shelby was now a 57-page bill, and it was first posted on the internet. The next morning, Apodaca's Rules Committee held hearings on the 57 pages, but they were just rush. The same-day registration that was very popular in the black community and had been functioning flawlessly for 6 years and 3 major elections was gutted. Please, that's the story. They took away, or attempting to take away, what North Carolinians have already been using.
Yes.
Counting valid votes that were cast in neighboring precincts, this was also eliminated. Now, the lower court found, interestingly, that all of the facts were true, that we were not wrong on the facts. Judge Schroeder said that the North Carolina NAACP and our co-plaintiffs may very well be able to prove that these statements and others made by the extremists who are frightened by the steady growth of fusion voter coalition and the rise in voting by people of color would go a long way to proving discriminatory intent in our big trial, not hearing next summer, but in our big trial next July. In other words, we very well may be able to prove that what they've done is unconstitutional. Interestingly, after saying that, he also said the denial of a constitutional right, such as the right to vote, constitutes an irreparable harm. This is what the middle court judge said. But then he contradicted himself by finding that the burden imposed by the elimination of same-day registration is slight, and that same-day registration was a preference. Therefore, it did not constitute irreparable harm. He says the denial of a constitutional right first constitutes irreparable harm.
Right.
But then he contradicted in the same ruling that the burden imposed by the elimination of same-day registration is slight and a preference, and therefore it did not constitute irreparable harm. And using this logic, because he says that it's just a preference, then that means as long as there are other ways to vote, everything would be fine. Well, using that logic, poll tax would be all right. Literary tests would be fine as long as there are other ways to vote. Now, the Court of Appeals straightened out this self-contradiction. The appeals court said that Judge Schroeder got the law plainly wrong in several crucial respects. When the applicable law is properly understood and applied to the facts that the district court portrayed as facts, it becomes clear that the district court abused its discretion in denying plaintiffs a preliminary injunction. In other words, we're not going to let these laws go forward because they need to be litigated in court, and if they go forward, they have the possibility of taking away somebody's constitutional rights, and if you take away my constitutional rights, I may gain those rights again, but I can't get back what I've lost. That's all a preliminary injunction basically is for a country boy.
All right.
All right. It says, abuse its discretion to deny plaintiffs a preliminary injunction and not preventing certain provisions of House Bills 7589 from taking effect while the parties fight over the bill's legality in a 2-week trial. And I keep saying that because I think in the media somebody has said we're having a hearing next year. No, it's a full trial.
Yes.
So they say in this, accordingly, we reverse the district court's denial of the preliminary injunction as to House Bill 589's elimination of same-day registration and prohibition on counting out of precinct ballots, because the court said we should not be keeping people from voting, and we should not be denying them their constitutional rights. That is not a small victory after Shelby.
That's right.
That is a huge victory.
That's right. Huge.
And a victory for the movement and a victory for movement lawyers.
Yes.
In short, the Court of Appeals found that the lower court was dead wrong in its fudging the meaning of irreparable damage. Now this is a critical piece about constitutional law. The court said when one black voter, not 10, not 2, not 3, not 1,000, when one black voter is denied his or her right in November, that is irreparable.
All right now, that's what I'm
The whole
talking about.
purpose of the Constitution is to protect a minority from the tyranny of the majority.
That's right.
And the court said if just one, we know it would be many, but if just one, then a preliminary injunction must be issued to stop that. That is the decision of the court, that constitutional rights trump politics.
Yes.
It trumps extremism. And it even trumps the possibility of an administrative burden by the state, because the state is required to fix it, because the greater burden is to deny or abridge somebody's right to vote.
That's right.
Period.
That's right.
Next July, there will be this trial. And we're going to have witnesses testifying in that trial. We will have our full day in court. Now, I close by commenting on the question of whether there is time to implement the appeals, because that was basically the state's argument. The state, in essence, said, well, there may be some problems here. We might disenfranchise some of the members of Dr. Mendez's church and take their constitutional right to vote, Dr. Hawkins' church. We might disenfranchise Latinos. We might, disenfranchise Miss Rosanelle Eaton and others like her, black and elderly women. And if we had time, we'd fix it. But we've already started. The problem with that logic is, listen at it in historical application. Slavery may be wrong, but we've already started.
Yeah.
Jim Crow may be wrong, but we've already begun. Literary tests may be wrong. Poll taxing may be wrong. Discrimination against women may be wrong. Mistreating people who are disabled may be wrong. Not allowing people to have equality in public services may be wrong, but we've already started. And you can't burden the state with now having to correct something that we've started. But if this country could change after 250 years of legal slavery and 100 years of Jim Crow, surely we can adjust to ensure that people's constitutional rights are not taken before this November election begins. All this did was restore 2 voter enlargement programs, same-day registration and preserving the vote even if you don't vote in a neighboring precinct. All county boards of elections have implemented these programs for several elections. They are equipped to do it now. It is not a burden. In fact, the State Board of Education should have had a plan B to start with, because they know that we're in court.
That's right.
This is not being done in the dark. It's not being done in secret like that 57-page bill was put together. We have been doing our work in the open. They knew it was a possibility, and if not a probability, that the Fourth Circuit would restore some of the voting rights stripped by the voter suppression bill. The State Board of Elections, they have good lawyers. They know the fundamental constitutional principle that violating one voter's constitutional right and abridging her right to vote is irreparable damage. They knew, or they should have known, and they should have a plan B, and that's the question the media should ask. Do you have a plan B? Why? Why would you set all of your systems on go without a plan B, knowing that it was being litigated in court? Were you that confident that the courts would agree with the extremists? And if so, why? Why? And why would you cry foul and cry burden as the State Board of Elections when your fundamental reason for existing is to ensure
That's right.
that people in this state have a board of election that protects and implements the right for people to vote.
That's right.
That's your job, not a burden. And already this morning, thanks to Jamie Phillips, and I'm through here, and Irv, and the good people, our good attorneys, it's amazing. The Guilford County Board of Election has already said we hadn't done all of our training or printed all of our training materials as early as we normally had. We were kind of keeping our options open. I know that we're not saying the county board had a section B and the state board didn't. So now that we know which way to go, that's easy. That's Guilford, that's big county. Huh? And we're going to rely on the state board of election to help us out. So now we don't need the state board of election hindering what the counties are saying they can do.
Yes.
And Charlotte, what did you give me, James? Charlotte Mecklenburg, the director of the Mecklenburg County Board of Election, Michael Dickerson, you can call him, says it actually won't be hard for the county to retrain its workers on same-day registration out of precinct. But even if it was hard, it's not as hard as after years of denial, watching in the 21st century your constitutional right to vote being abridged.
That's right.
That is the greater burden. But the fact is, we can correct this. We can correct it now, and we must correct it now.
Yes.
Thus has said the courts. But more importantly, thus says the principle from 1870. No one, no state, no entity, nobody can deny or abridge the right to vote in this country. Not now, not ever.
Let me just say this legal opinion from the Fourth Circuit Court of Appeal starts out with a fundamental notion that the right to vote is fundamental.
Yes.
That is the very first thing that Judge Wynn said in his opinion. No right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. Now that's the beginning of this opinion, and it runs for 69 pages. But essentially what the court has done is to clarify the legal tests that Judge Schroeder was not able to comprehend in his opinion. As Dr. Barber has indicated, there are no differences as to the facts, because Judge Schroeder found facts that would support a claim of discrimination and voter violation, voter rights violation. The test, the legal test, dealing with the totality of circumstances is what Judge Wynn talked about. And that this right is one that is fundamental not to the group or to a majority of citizens, but a fundamental right as it relates to each individual citizen. And that's a part of the guarantee or the contract that exists between the people and their government. And in this instance, the government is responsible for ensuring that each individual citizen, not all of them, not a caucus of them, but each individual citizen can enjoy that fundamental right to vote.
Yes.
So that's the legal opinion. And Judge Wynn appropriately set that out and explained in detail exactly how that is to be interpreted within the Fourth Circuit. What Judge Wynn spoke to was basically law already developed by the U.S. Supreme Court and established all over the country now in the voting rights jurisprudence. So from a legal perspective, this is a very sound opinion that is supported amply by Supreme Court precedent, both in circuit courts and in the U.S. Supreme Court. Now, as we had predicted, as soon as this opinion was filed and the state was able to print it off, they had a bus headed to Washington to file an appeal. All right? Before you knew about it, they were on their way to Washington to file this appeal. Now, what we are looking at probably is a decision from the Supreme Court in the next few days, probably by Tuesday or Wednesday at the latest. And the question is whether the U.S. Supreme Court is going to adhere to its legal precedent or whether it is going to rely upon its political leaning and issue a political decision that is designed to buttress what these right-wing conservatives are doing in state courts. We know that in the past, the U.S. Supreme Court has issued political opinions. But if it adheres to the law based on its own precedents, then it is going to have to uphold the Fourth Circuit opinion that was issued by Judge Wynn. But if it becomes political, and by political I mean supporting the ability of this state to disenfranchise or to deny, or as Dr. Barber talked about, abridge the right of any individual citizen in the state to vote, then it will vote to stay that opinion. At any rate, no matter what the Supreme Court does, our work is going to be exactly the same. And whether we are dealing with a deadline of October the 10th, we're going to have people registered to vote and ready and prepared to vote beginning on October 23rd. Even if we're dealing with same-day registration, where we go into this early voting period, we will still have to focus on registering the people to vote and then having them to actually vote. And in fact, it'll be a lot easier if we do same-day registration, but the loss of that will not be fatal to the effort in which we are engaged. It will be legally contradictory for the court to take away what Judge Wynn has restored, because this is not anything new.
That's right.
This is just a restoration of what the law was in North Carolina, and that every election official in the state are used to having same-day registration. Right. They're used to having to count provisional ballots that are out of precincts. So that is nothing new that they have to do. And the only thing that Judge Wynn said in his opinion is that as to those two areas, the inability of people to vote out of precinct or to vote on the same day creates irreparable injury to those people who will be affected, because if they don't register by October 10th, they will be disenfranchised. That's right. Now this takes on more meaning in light of some of the shenanigans that's going on around in the states right now. Right. You got everybody and their mama coming in here from all over the country telling people how to vote, how they should register, and they're giving out false, misleading, and confusing information, and that is on purpose. Yes. It's not by accident. These are not illiterate people.
That's right.
You know, these are not illiterate people. They know how to read. All right? So do we. we can read as well as they can. The legal opinion says that we're right. and that we are on sound ground in going out to get our people in to register to vote, whether it is by October the 10th or whether it is during the early voting period. And now it's going to be up to the Supreme Court to make some determination about which side it's going to stand on. Now, we know already that there are at least 4 votes on the Supreme Court leaning on the conservative side. They lean on the conservative side because that's the side of the bed they get up on every morning. This is a sound opinion. We think that there are 5 votes that will support this opinion. But even if they don't,
That's right.
it will not destroy the momentum that we have developed. It will not destroy the strategy that we have developed. And we will move forward because we know that when we come back to the court in July, with this legal standard in place that Judge Schroeder has to comply with, that we're going to be victorious.
Yes.
That's right.
The problem is, what are we going to be able to carry with us when we go into that election? So I'm very proud of this opinion and the legal team that we had fighting this battle. Judge Wynn has written a masterpiece. Here we support it, and it is the law of the land for the Fourth Circuit, irrespective of anything that the Supreme Court will do. So this foreshadows what the decision will have to be
That's right.
in July when we go in for the full trial that is going to occur in the Middle District. So I would answer any questions that you might have.
Any questions from members of the media? If you'd like to talk to Attorney Irv, Attorney Al, individually, we certainly would welcome you to do that. And if there are no questions, wait just one second.
Well, for the Reverend, I wanted to ask is, similar to what Irv Joyner was just saying, what, if the Supreme Court decides to block this decision, what will be the course of action that it will take?
Well, remember, the NAACP and people who believe in freedom and justice have always had to do 2 things. We celebrate when America gets it right. We challenge America when it gets it wrong. And so we will do what we always have done. If they choose to overturn it, then we will fight against it. We will do all of the organizing, and we will deal with the hand we are dealt, but we will never accept that hand if it's a hand of injustice. So we will deal with it in the election. We will battle it in the courts. We're on go. Our young people all over this state have been registering people to vote. Our branches are registering people to vote. We're doing Monday march to the polls all over this state, pushing people to vote. Clergy all over this state are joining and registering people to vote. In fact, the very attack against a right so precious has stirred people in a way that they might not be stirred if the attacks were not going on. We got a new branch up in Asheville. I'm learning some new language, this predominantly white branch, the NAACP, kind of like the original NAACP. And they have a phrase up in the mountain. They say, the new president introduced me. She said, "Reverend Barber, these extremists have poked the bear." And they said that's the most dangerous thing you can do is poke the bear when the bear sleep. Well, I want to say not just in the mountain, but all over North Carolina. When this extremist legislature led by Tillis has attacked sick people, attacked the poor, attacked public education, attacked LGBT, attacked immigrants, and now, after doing all of those things, chose to go after the most precious of our rights, the right to vote, the one that you heard Judge Wynn saying his opinion, all the other rights are just illusory without that one. They have poked the bear and anything else that could be poked. And you can feel it in the air, you can see it in the eyes of the people there is a fight and a determination that we are not going to let anything turn us around. Yes.
I just have one other question, which is regarding the county boards. Some of them are reporting that they're getting a much higher volume that they've seen in midterm elections, maybe even in presidential elections.
Sure.
I know that the NAACP has made a big emphasis on voter registration drives this summer. Some theory as to why there's such a high volume is that perhaps the Hagen-Tillis campaign is drawing a lot of attention.
Well, I think not only NAACP, but all 160 of our HK on J Forward Together movement partners, you can't just isolate this. This, before you get to the Senate race, look at the pain that this state legislature and governor has inflicted in the lives of people. I mean, their policies have not just, it's strange, they pass policies that hurt disproportionately African Americans, but this extremism is so bad, it hurts their own people. It hurts people that voted for them.
That's right.
I run into people, and when I'm working out in the morning, saying, Reverend Barber, I want to apologize. You say, for what? Well, I'm a Republican. I voted for this. And I didn't know they were going to cut teachers. I didn't know they were going to take away 900,000 working people's earned income tax credit. I didn't know they were going to take away unemployment and accident. You know, when you cut 500,000 people's Medicaid and 2,800 people die, that is not just black people. That's white, Native American, Asian, Latino, Republicans, Democrats, Independents. So it is this, there's always an equal opposite reaction. What you see is a group of legislators led by Tillis and Barber, signed off by the governor, who are so drunk with this Tea Party ideology, so misinformed by this ALEC ideology, and so paid off by this Coke money and Pope money, that they are just drunk with power. And absolute power corrupts absolutely.
Yes.
It's the politics without principle. But when you engage in that, it makes people push back. And that's why we're seeing, notice what you have seen with the Forward Together movement. Black and white, Latino and young and old coming together like you've never seen in the South. Why? Because the pain index has risen. And because of that, the passion index is rising.
Yes.
And people have a passion now to get involved. Yes, the Senate race, but remember, they know we're also electing every member of that state legislature.
That's right.
And people have told me, Reverend Barber, even if we don't unelect all of them, we're going to send a signal.
Send some home.
We're going to send a signal that there will never again be an off-year election, because we now see clearly the results of allowing extremism to take over. And that's what Tillis and Barber, they don't necessarily represent republicanism, they represent a hijacking of the Republican Party by extremism.
Yes.
One more.
So this emphasis on registration is because of the General Assembly races? It's not because of this law that could potentially block people from...
It's all of the above. You can't pin it down to one thing. That is the combination. Let me give it to you in country boy way. Don't get offended by this. If I hit you in your nose, your whole body gonna feel it. Your whole body's gonna react. Your nose is gonna hurt. Your legs gonna get weak. Your eyes gonna water. You understand what I'm saying? So what I mean by that is they have done so much that's so extreme that there's no one reason that people are motivated, but the fact is people are motivated.
That's right.
Now you might be able to say that the coup d'etat is to do all of this damage and then say, now I'm going to undermine your ability to judge me at the ballot box. And that becomes the ultimate insult. So all of that, all of the above, but the attack on the fundamental right to vote is the most grievous of all of them. And it has caused people to say, we have to stand up against this all over the state. And not only in North Carolina, all over this country, in particular all over the South. This is not a dictatorship. This is the democracy.
Yes.
And when you see this battle to go backwards, particularly in the South, it doesn't just frustrate people, it angers them. It doesn't just make them mad. Mad is, you might mad and just walk away. But anger, the form of anger and mourning, it makes people grieve deeply. When I think about this, I think about the graves. Every time I think about it, why would you attack the right to vote when every time you do that, you desecrate the graves and the memory of those who died that we might have this? And it's almost as though, in a spiritual sense, you hear the blood crying out from the ground saying, don't allow this to happen. So people are moved at a very, not only political level, but they're moved at a very moral and spiritual level when you start attacking the right to vote. We're in a serious soul searching in this state right now. And people's souls have been touched because they see this as a form of political madness. Why would politicians not want people to vote?
That's right.
That's a serious question.
Yes.
For someone that gets elected by the vote to then use their elected power to undermine the vote. What's behind that?
They don't want to be accountable.
But a level of extremism and the desire to have politics without principle.
Yes.
That's all. That's the only answer for it.